I turned onto Lakeview Drive at just past 4 in the afternoon. Same gravel road. Same bend at the old oak. Same feeling in my chest. That quiet unwinding that happens the second you get close to the lake. And then I came around that bend and put the truck in park right there in the middle of the road. Where my wildflower meadow used to be, the one my father planted in 1993, there was a freshly paved parking lot, painted lines and everything. And sitting right on the edge of my property was a wooden pavilion. Brand new. Still smelled like sawdust, 4 picnic tables underneath it. An HOA sign planted in the ground like a flag someone had claimed territory with. There were still workers on site. One of them looked up and waved me around like I was holding up traffic, like I was the inconvenience. I'd been gone 90 days. In 90 days, the HOA had built a community recreation facility on land that had been in my family for 31 years. And the worst part? They had paperwork. My name is Cole Branson. I'm a civil engineer. I travel for work, infrastructure contracts, mostly, which means I'm used to being somewhere other than home for months at a time. It's not a glamorous life, but it's a good one. Predictable. Structured. I like things documented, I like things measured, and I like knowing exactly where every boundary line falls. My father was the same way. He bought this lakeside property in 1991, a corner lot on a private lake in a small community of 34 homes. He built the cabin himself over 2 years, planted that wildflower meadow because he thought wildflowers were underrated, and put a bench facing the water where he drank his coffee every single morning until the day he couldn't anymore. He left it to me 3 years ago. I spent the first 2 summers after that restoring everything, the cabin, the porch, the meadow, the dock. Not because I had to. Because it felt like the only way I knew how to grieve. This property isn't an asset to me. It isn't an investment. It's the last place on earth where I still feel like his son. So when I came around that bend and saw what they'd done, I want to be clear about something. This was never just a property dispute to me. This was personal from the very first second. I pulled into my driveway and stepped out of the truck. The 2 workers on site stopped what they were doing and looked at me. Neither of them said anything. I didn't say anything either. I just stood there, looking at my property, at the concrete pad, the pavilion, the gravel path running straight across my recorded boundary line like it was nothing. And I took a slow breath. Then I heard a car door. A white SUV had pulled up behind me. I hadn't even heard it come down the road. The woman who stepped out was somewhere in her late 50s, dressed like she was heading to a board meeting, pressed blazer, dark slacks, sunglasses she took off in one smooth motion as she walked toward me. She was carrying a manila folder. She moved like someone who had never once in her life been caught off guard. She smiled and said my name. Not hello. Not can I help you. She said my name, Cole, like she'd been expecting me. Like this was a meeting she'd scheduled. I did not smile back. Her name was Sandra Voss, HOA president. I'd seen her name on 2 pieces of HOA correspondence before I left for Nevada, both routine, both forgettable. She had not made a strong impression on me then. She was making one now. She extended her hand. I looked at her for a moment. I didn't take it. She didn't miss a beat. Just tucked her hand back to her side and opened that manila folder like we were already mid-conversation. She told me the HOA had exercised its rights under an easement provision in the community's original 1987 governing documents. She said the provision granted the association access to peripheral lots for community infrastructure purposes when an owner had been absent for more than 60 consecutive days. She said the board had voted unanimously at 3 properly noticed emergency meetings. She said certified mail had been sent to my Nevada address at each stage. She produced copies of the mailing receipts right there, slid them across the hood of my truck like she was closing a real estate deal. She was calm. She was prepared. She had an answer for everything before I even asked the question. I picked up the mailing receipts. The zip code on every single one was off by 1 digit. They were never delivered. But I didn't say that yet. I filed it away. Then she handed me a copy of the easement claim itself. 38 pages, tabbed and highlighted. I took it. I stood there in the afternoon sun, and I read it. Not skimmed it. Read it. Because I'm a civil engineer, reading legal property descriptions is literally part of my job. I know what a lot number looks like. I know how plat maps are structured. I know exactly how these documents are supposed to be written. And about 4 pages in, I found it. The easement provision Sandra was citing referenced a specific lot number. The lot number in the document was Lot 14. I own Lot 41. 2 digits. Transposed. It sounds like a small thing until you understand that in property law, a lot number isn't a label. It's a legal identity. Lot 14 and Lot 41 are as different as 2 separate human beings. The easement Sandra was using to justify a $47,000 construction project on my land was written for an entirely different property. I looked up from the document. I told her very quietly that the lot number in the easement provision did not correspond to my property. She didn't flinch. She said the board's legal counsel had reviewed the document thoroughly and confirmed its validity. I told her I'd like her workers off my property by end of day. She said the structure was now a community asset and that removal would require a full board vote and a formal hearing process. She said she understood this was a difficult situation to come home to and that she was happy to schedule a meeting at my earliest convenience to walk me through the board's decision-making process. Then she put her sunglasses back on, tucked the manila folder under her arm, and walked back to her white SUV. I stood there and watched her drive away. Then I turned back around and looked at the pavilion sitting on my father's land, on his meadow, on his sile, under his sky, and for the first time since I'd come around that bend, I felt something move through me that wasn't shock anymore. It was clarity. She thought I was going to be difficult to deal with. She had no idea what difficult looked like yet. I didn't sleep that night. Not because I was panicking. I want to be clear about that. I've managed multi-million-dollar infrastructure projects with 6-month deadlines and 30-person crews. I know how to stay level when things go wrong. What kept me awake that first night wasn't fear. It was the particular grinding alertness of a man who knows he's been wronged and is already thinking 3 steps ahead. The pavilion was visible from every east-facing window in the cabin. Sandra had installed a motion sensor floodlight on it, on my property, and every time the wind moved the tree branches, the light kicked on and lit up my bedroom ceiling. I lay there in the dark watching it pulse on and off, and I made a list in my head of every document I needed to pull. By midnight, I had them all spread across my father's kitchen table. My original deed. My father's deed before it. The HOA's governing documents I'd signed at closing 3 years ago. The certified mail receipts Sandra had given me. My own copies of every piece of HOA correspondence I'd ever received. I photographed everything with my phone before I touched a single page, timestamp on every shot. Then I went through it all line by line. The zip code error on the certified mail receipts was consistent across all 3 mailings, 1 digit off every time. That's not a typo, that's a pattern. It meant every notice Sandra claimed to have sent me during those 3 emergency meetings had gone to an address that didn't exist. I had never been properly notified of a single vote. I wrote that down, circled it, set those receipts aside in their own pile. Then I went through the governing documents. The easement provision Sandra had cited did exist. It was real. It was in the original 1987 HOA charter, but it was written with a specific lot number attached to it. And the lot number in the HOA's version of the document didn't match what I needed to verify against. I needed the original, the actual 1987 filing. Not Sandra's copy, the county's copy. I was at the county recorder's office when it opened at 8 the next morning. The clerk pulled the original 1987 plat map and the original HOA charter from archive. I stood at the counter and compared them page by page against Sandra's version. It took me 11 minutes to find the discrepancy. The easement provision in the original 1987 filing referenced Lot 14, a vacant lot on the north end of the community that had been designated common area since 1994. Empty land. Land the HOA already owned. The provision had been written specifically for that lot. In Sandra's filed version, the version she'd submitted to the county sometime in the past year, the lot number had been changed. The font weight on the number was slightly different from the surrounding text, barely visible. But I'd been staring at engineering schematics and technical documents for 20 years. I saw it. I requested certified copies of both the original document and the HOA's filed version, and paid the $12 fee without blinking. Then I called Diane Mercer. A colleague had recommended her 6 months earlier in an unrelated conversation. HOA law, property rights, exactly this kind of dispute. I'd written her name in my phone and forgotten about it. I found it in my contacts on the drive back from the recorder's office. I gave her the situation in 5 minutes flat. No emotion, just facts. Timeline, lot numbers, certified mail discrepancy, document comparison. When I finished, she was quiet for exactly 2 seconds. Then she said, "Did you get a certified copy of the original plat?" I said yes. She said, "Come in tomorrow morning. And don't speak to Sandra Voss or any board member before you get here." I liked her immediately. That evening, I walked the full perimeter of my property for the first time since I'd been back, not to inspect the damage. I'd already done that. I walked it the way my father used to walk it, slowly, hands in his pockets, like he was just checking in on things. The oak tree he planted the year I was born was still there, untouched, just outside the construction zone. The bench facing the lake was still there. The concrete pad stopped about 8 feet short of it. Whether by accident or because even Sandra had a limit, I didn't know. I sat on that bench for a while as the sun went down. I thought about my father, who bought this lot with careful money and careful paperwork and a deed restriction he'd had written in at closing, because he believed in doing things right the first time. I thought about the fact that I hadn't even known about that deed restriction yet. I'd find it later, in the county records, 2 pages behind the original deed. But even then, sitting on that bench in the dark, I had the feeling that he'd left me something in those documents, some protection I hadn't found yet. I was right. The next morning, I met with Diane. I laid everything on her conference table. She went through it quietly, methodically, and when she got to the certified copy comparison, original versus Sandra's filed version, she stopped. She put her reading glasses on. She looked at it for a long moment. Then she looked at me and said, "This is document alteration. You understand that, right? This isn't an administrative error. Someone changed this." I told her I understood. She told me we were going to file for a temporary restraining order to halt any further construction or modification on my property while the dispute was in litigation. She said we'd have it in front of a judge within 48 hours. I nodded. Then she said, "I have to ask you something, and I need an honest answer. Is there anything about this property, your ownership history, or your relationship with this HOA that could complicate our position?" I thought about it for exactly 1 second. I said, "My father had a deed restriction written in at closing in 1991. I haven't pulled the full language yet, but I know it exists." Diane wrote that down without looking up. "Find it," she said. "Today." I went back to the county recorder's office that same afternoon. 2 pages behind my father's original 1991 deed, stamped and dated, was a 1-paragraph restriction that specifically excluded Lot 41 from any future blanket HOA easement claims. My father had seen it coming. Not Sandra specifically, not this situation exactly, but the general shape of it. He was that kind of man. He read everything twice, and he made it hard for anyone to undo what he'd built. I sat in my truck in the recorder's parking lot and held that certified copy for a long time. Then I drove home. The TRO was granted 48 hours later. Sandra was served on a Thursday afternoon. According to Ray Kowalski, my neighbor 2 lots over, retired electrician, 71 years old and the most quietly observant man I have ever met, she was standing in her driveway when the process server arrived. Ray said she read the document standing right there, then went inside without a word. Ray had been watching. Ray had been watching everything. He came over that same evening, knocked on my cabin door, and handed me his phone. On it was a photograph he'd taken during the first week of construction. A site permit, stapled to one of the pavilion posts. The permit listed the construction start date. It was 4 days before the first HOA emergency meeting had even taken place. They'd started building before they'd voted, before any procedural pretense of authorization. The meetings, all 3 of them, had been staged after the fact to create a paper trail for a decision that had already been made and a structure that was already going up. I looked at Ray. He shrugged like a man who'd always known something was wrong and was glad someone was finally in a position to do something about it. "Thought you might need that," he said. I told him he had no idea. "I want to tell you something about Sandra Voss. She was not the kind of person who panics. She was not the kind of person who second-guesses herself or retreats when she meets resistance. In the weeks that followed the TRO, I came to understand that Sandra operated on a very specific philosophy. That most people, when faced with enough pressure, enough paperwork, enough financial bleeding, will eventually decide that fighting isn't worth it. She wasn't wrong about most people. She was wrong about me, but she didn't know that yet. So she did what she always did when someone pushed back. She escalated. The first move came on a Monday morning, exactly 6 days after the TRO was served. I was sitting at my kitchen table going through documents when my phone rang. It was a woman named Karen. She and her husband had booked the cabin for 2 weeks in July, one of 2 summer rentals I had confirmed before I'd left for Nevada. She was apologetic, clearly uncomfortable, and she told me she'd received a letter from the Lakeview HOA informing her that my property had been flagged for unresolved code compliance issues and that her booking might be affected by ongoing legal proceedings. She canceled. I thanked her for calling me directly, hung up, and immediately checked my messages. The second summer booking, a family of 4, 10 days in August, had sent an email 2 hours earlier. Same reason. Canceled. $6,400 in confirmed rental income. Gone in a single morning. That money covered my property taxes for the year. I forwarded both cancellation messages to Diane without a word. She called me back in 20 minutes and said, add it to the damages list. She just handed us financial injury documentation. I appreciated that. But I want to be honest. Sitting in that cabin, looking at those 2 cancellations on my screen, was one of the harder moments of this whole thing. Not because of the money exactly, because of the calculation behind it. Sandra hadn't done this out of anger. She'd done it coolly, deliberately as a resource depletion tactic. She was trying to make this fight expensive enough that I'd consider settling. She knew I covered my property taxes with rental income. She'd done her homework. That bothered me more than the money. The second move came 4 days later. A formal HOA notice arrived at my door, hand-delivered by Phil, Sandra's assistant, a thin, nervous man in his 40s who couldn't quite make eye contact when I opened the door. The notice informed me that my truck, parked in my own driveway, was in violation of HOA parking guidelines. The specific reason cited was that my driveway had been reclassified as adjacent to a community access corridor, the gravel path the HOA had installed across my property, and therefore fell under new parking restrictions that had been passed at the third emergency meeting. The fine was $200. I read the notice twice. Then I took a photograph of it, forwarded it to Diane, and parked my truck in the exact same spot. I will be honest. There was something almost impressive about it. Sandra was building a violation record. Every fine she issued, even an illegitimate one, created a paper trail that she could use in court to characterize me as a non-compliant homeowner. It was the kind of move a former corporate attorney makes, methodical, forward-looking. She wasn't just fighting today's battle, she was trying to shape the narrative of the whole war. Diane filed a motion challenging the parking fine and the reclassification of my driveway within 48 hours. But the message was clear. Sandra intended to make every square foot of this property a battlefield. The third move was the one that surprised me most. I got a call from the county building department on a Wednesday afternoon. A complaint had been filed. Anonymous, they said, though we both know who filed it, alleging that my cabin contained an uninspected addition. Specifically, the screened porch on the east side of the cabin. The complaint triggered a formal inspection request. The screened porch was built by my father in 1988, with a permit that had been properly filed with the county 37 years ago and had long since been moved to archived records. Sandra was counting on the fact that a 37-year-old permit would take weeks to locate, weeks during which the inspection would be pending, the complaint would be active, and I'd have one more fire to put out. What Sandra didn't account for was that I am a civil engineer who has spent 20 years working with municipal permit systems. I know exactly how county permit records are indexed. I know which filing codes they used in the 1980s, which ledger systems were standard before digital archiving, and how to request a microfiche pull from a county records department in a way that gets results the same day. I had the archived permit in my hands by Friday morning. I submitted it to the building department before the inspection was even formally scheduled. Complaint dismissed. I didn't feel triumphant about it. I felt tired, because that was 3 moves in less than 2 weeks, rental sabotage, fabricated parking violation, fraudulent building complaint, and Sandra hadn't even broken stride. She was running a full-court press and she had more resources than I did. She had the HOA's legal budget, her own background as a corporate attorney, and 20 years of experience using process as a weapon. What she didn't have was Ray Kowalski watching her from 2 lots over. Ray had become my unofficial intelligence source by this point. Not because I'd asked him to, but because Ray was the kind of man who paid attention to his surroundings and had very little patience for people who thought they could operate in a neighborhood without being noticed. He called me one evening and told me Sandra had reached out to a local TV journalist, a woman who covered neighborhood interest stories for the regional news station. Ray said he'd seen the journalist's car parked outside Sandra's house for about an hour on a Tuesday afternoon. The segment aired that Thursday evening. I watched it alone in the cabin. The angle was exactly what Sandra had pitched, a community gathering space threatened by a dispute with an out-of-town property owner. They showed the pavilion, the picnic tables, the string lights. They interviewed 2 residents who talked about how much the community needed a space like this. They didn't use my name, but they used my lot number. And the comments on the station's Facebook post were not kind. I sat there watching it and I thought about all the people in that comments section who had no idea what the actual document said, who had no idea about the lot number alteration, the invalid board vote, the self-dealing construction contract. All they knew was the story Sandra had handed them, a pleasant pavilion and a difficult man trying to tear it down. I want to be honest with you about those 48 hours after that segment aired. That was the closest I came to feeling like I might not win this. Not because the evidence wasn't there. The evidence was solid. Diane had told me that more than once. But evidence has to survive contact with public perception, and public perception in those 2 days was not on my side. I called Diane. She told me what she always told me. Stay off social media. Don't respond publicly. Let the documents do the talking. She said the TV segment would look very different in 3 weeks when the full picture came out. She said Sandra had just made her first real mistake by going public, because going public cuts both ways. She was right. But I didn't know that yet. So I sat in my father's cabin, in the dark, with the pavilion floodlights cycling on and off outside my window, and I thought about what he would have done. He would have gone back to the documents. So that's what I did. Diane filed a formal public records request for every HOA financial transaction over the past 3 years. She told me it was standard procedure, the kind of request she filed in almost every HOA dispute she handled. She told me not to expect much. Most of the time these things came back clean, or clean enough that the financial angle didn't move the needle. She said we had plenty without it. The document alteration, the deed restriction, the invalid board vote. She said the financial request was due diligence. What came back 3 weeks later was not what either of us expected. 340 pages. A full financial document dump covering every HOA expenditure, every budget amendment, every vendor contract from the past 36 months. Sandra had clearly not anticipated that anyone would request this level of detail. Or if she had, she'd decided the risk of refusing was greater than the risk of complying. Either way, she handed it over. Diane called me on a Friday afternoon and said, "Can you come in tomorrow? Bring coffee. This is going to take a while." We spent that entire Saturday going through it page by page at her conference table. The pavilion construction had cost $47,000. I already knew that from the contractor paperwork we'd obtained through discovery. What I hadn't known was where that money came from. The HOA's annual maintenance budget was $31,000. The overage, $16,000, had been approved to a budget amendment passed at the second emergency meeting. The amendment was categorized under a line item called Community Infrastructure Reserve Deployment. I read that line item 3 times. Community Infrastructure Reserve Deployment. It didn't exist in any previous HOA budget. It had been created specifically for this amendment, at a meeting held while I was in Nevada with no notice sent to me and passed by a board vote that Diane flagged immediately. HOA bylaws required a 2/3 majority for any budget amendment. The board had 5 members. 2/3 meant at least 4 votes. Sandra had recorded 3 votes in favor, including her own vote as president, and had noted in the minutes that she'd cast an additional vote as a tiebreaker. There was no tie. There were only 3 votes. Sandra had invented a procedural mechanism to manufacture a majority that didn't exist. The amendment was invalid. The funding authorization was invalid. $47,000 of construction had been approved through a vote that never legally happened. I wrote that down. Circled it twice. Then Diane turned to the vendor section. The construction contract for the pavilion had been awarded to a company called Voss Property Solutions, LLC. I looked at that name for a moment. Voss. Sandra's last name was Voss. I looked at Diane. She was already pulling up the state business registry on her laptop. Voss Property Solutions, LLC had been registered 8 months before the construction began. The registered principal was a man named Daniel Kessler. Diane cross-referenced the name against public records in about 4 minutes. Daniel Kessler was Sandra's brother-in-law, married to her younger sister for 11 years. His address on the LLC registration was a house in the next county over. Sandra had created a shell company under her brother-in-law's name, awarded the HOA construction contract to that company, and used HOA funds collected from 34 homeowners, including me, to pay for it. The separation between Sandra and the LLC was exactly one person, a family member, a paper-thin layer that was clearly designed to provide technical deniability while keeping the money in the family. Diane sat back in her chair and looked at the ceiling for a moment. Then she said, "Cole, I need to make a phone call on Monday morning." I asked her who she was calling. She said she had a contact at the county planning office, someone she'd worked with on a previous case. She said she wanted to check something before she told me what she was thinking. I told her to check it. She called me Monday afternoon. Her contact had told her off the record, carefully, in the way that people share information when they want something done about it but don't want to be the one to do it, that a reclassification application had recently been filed with the county planning board. The application was requesting that the lake-adjacent common areas of the Lakeview HOA community, including any expanded amenity space, be reclassified under a new county ordinance as mixed-use recreational. I asked her what mixed-use recreational meant in practical terms. She said it meant the land could be commercially leased. I sat with that for a second. Then I asked who had filed the application. Diane said it had been filed by a consulting firm. She gave me the name. I wrote it down. Then she told me the name of the consulting firm's registered agent, Sandra Voss. The application had been filed 7 months ago, 4 months before the emergency HOA meetings, 5 months before construction began on my property. Sandra hadn't built the pavilion because the community needed a gathering space. She hadn't filed the easement claim because she believed it was legally valid. She had built that pavilion on my land because my corner lot was the missing piece of a real estate scheme she had been engineering for the better part of a year. The mixed-use recreational reclassification required a minimum square footage of lake-adjacent amenity space. The HOA's existing common areas fell short of that threshold by a specific margin. My corner lot, specifically the meadow and lake access strip that my father had protected with that deed restriction, closed the gap almost exactly. Sandra needed my land incorporated into the community's footprint to qualify for reclassification. Once reclassified, she planned to lease the lake frontage, the pavilion, the parking lot, the gravel path, all of it built on my property without my knowledge or consent, to a private boat tour company she'd already been in preliminary discussions with. Diane had found those discussions too. Emails between Sandra's consulting firm and the boat tour company obtained through our civil discovery request. The earliest email was dated 9 months ago. Sandra had been in talks with the boat tour company before she'd filed the reclassification application, before the emergency meetings, before the construction, before she'd sent a single piece of certified mail to a zip pi code that didn't exist. This had never been about community improvement. This had always been about money. I sat in Diane's office and looked at all of it laid out on the conference table. The altered document, the invalid vote, the self-dealing contract, the reclassification application, the boat tour emails, and I thought about Sandra standing in my driveway that first afternoon. Calm, prepared, smiling, sliding that manila folder across the hood of my truck like she was doing me a courtesy. She had known exactly what she was doing. She had known exactly what was in those documents and what wasn't. She had known about the deed restriction. She had to have known, because her attorney had to have pulled the full title history before filing the easement claim. She had known, and she had filed anyway, because she had calculated that I was an out-of-town owner who would either not notice or not fight. 31 years of my family's history on that land, and she had looked at it and seen a gap in her square footage calculation. I am a patient man. I have said that. I am slow to anger, and I try very hard to stay that way because I have seen what anger does to judgment, and I can't afford bad judgment right now. But sitting in that office, looking at those documents, I felt something shift in me. Not rage. Something quieter and more permanent than rage. Resolve. I told Diane to file everything. The fraudulent easement, the invalid budget vote, the self-dealing contract, the reclassification scheme, all of it, as a single consolidated complaint submitted simultaneously to the state HOA regulatory board, the county district attorney's office, and as exhibits in our civil suit. She nodded like she'd been waiting for me to say that. Then I called Ray. Ray listened to the whole thing without interrupting. When I finished, he was quiet for a moment. Then he said, "You know I've had 3 unexplained fines in the last 2 years. So has Margaret next door. So has Tom Ballou." I asked him how many neighbors he thought would be willing to file a joint complaint. He said, "Give me 2 days." He came back with 9 signatures. 10 homeowners, including me, filed a joint complaint against Sandra Voss and the Lakeview HOA board with the state regulatory authority. Ray had talked to every one of them himself, quietly. One conversation at a time, the way a man does when he spent 71 years learning how a neighborhood actually works. I also called the TV journalist, the one who had run the pavilion segment. I told her I had documents. I told her I could give her the full picture, the lot number, the altered filing, the shell company, the boat tour deal, and that I could back every single word of it with certified copies from the county recorder's office. She called me back in 2 hours. She said she wanted to run a correction and a full follow-up. Sandra had gone public first. But Diane had been right. Going public cuts both ways. The Lakeview HOA held its quarterly general meeting on a Tuesday evening in late October. Diane advised me to attend. She said it clearly and without hesitation. Go, be present, be calm, and let the documents do the work. She said Sandra would be expecting one of 2 things. Either I wouldn't show up, or I'd show up angry. She said I should give her neither. I pressed my shirt, brought a folder, and arrived 7 minutes early. The meeting was held in the community clubhouse, a low-ceilinged room with folding chairs, fluorescent lighting, and a whiteboard at the front that still had last quarter's agenda items half erased on it. About 22 of the 34 homeowners were there, which Ray told me afterward was the highest attendance in 3 years. Word had gotten around that something was happening. People could feel it even if they didn't know the details yet. I sat in the second row. Ray sat beside me. He'd brought his own folder. Sandra arrived 4 minutes after I did. She came in through the side door with Phil behind her carrying her binder, took her seat at the front table, and began arranging her materials with the unhurried efficiency of someone who had run 1,000 meetings and expected to run 1,000 more. She glanced at me once when she sat down. Just once. Her expression didn't change. She opened the meeting exactly on time. I will give her this. She was good at it. She moved through the agenda with the practiced rhythm of someone who had learned long ago that controlling the pace of a meeting is half of controlling the outcome. Maintenance updates. Landscaping contract renewal. Winter preparation schedule. She gave each item exactly as much time as it needed and not 1 second more. Then she said, "New business." I raised my hand. Sandra said comments from the floor would be held until the end of the agenda. Standard procedure, she said. I said calmly that I had a legal matter that was directly relevant to the association's current agenda and that my attorney had advised me I had standing to raise it under the HOA's own bylaws, specifically Section 4, Article 9, which gave any member the right to address the board on matters of active litigation during any general meeting. I had read those bylaws 4 times in the past 2 weeks. I knew them better than Sandra expected me to. The room was very quiet. Sandra looked at me for a moment. Then she said, "The chair will allow a brief statement." I stood up. I didn't use notes. I had thought about using notes but decided against it. Not out of confidence, but because I wanted to look at the room while I spoke, not at a page. I wanted people to see my face. I started with the lot number. I explained in plain language what a lot number is and what it means in property law. I explained the difference between Lot 14 and Lot 41. I explained that the easement provision Sandra had used to authorize construction on my property was written for a different lot, a lot the HOA already owned, and that the version filed with the county contained an alteration that did not appear in the original 1987 document. I had brought printed copies of both. I passed them down each row. People started reading. I explained the certified mail issue, the consistent zip code error across all 3 meeting notices sent to my Nevada address. I explained that I had never been properly notified of a single emergency meeting. I explained a construction start date on the site permit Ray had photographed 4 days before the first meeting took place. I explained the budget amendment, the 5-member board, the 2/3 requirement, the 3 votes, and the tiebreaker Sandra had applied to a vote that was never tied. I explained Voss Property Solutions, LLC, Sandra's last name, her brother-in-law as principal, the construction contract awarded to that company using HOA funds, and then I explained the reclassification application, the mixed-use recreational designation, the consulting firm, the boat tour company, the emails that predated every meeting, every vote, every certified letter sent to a zip code that didn't exist. I said this was not a community improvement project. This was a private real estate transaction conducted using this association's legal authority and this community's money, and it was built on my property without my knowledge or my consent. Then I sat down. The room stayed quiet for a moment that felt longer than it was. Sandra began her rebuttal immediately. She was composed. I expected nothing less. She used the word mischaracterization 4 times in the first 2 minutes. She described my presentation as a selective reading of complex legal documents by someone without a legal background, which I found interesting given that she knew exactly what my professional background was. She said the lot number discrepancy was a known administrative error that the board's legal counsel had already reviewed and determined did not affect the validity of the easement. She said the budget amendment had been passed in full compliance with the bylaws. She said Voss Property Solutions had been selected through a competitive bidding process, and that any connection to her family was a coincidence she had disclosed to the board. She was disciplined. She was articulate. She had an answer for everything. But the room was different now. I could feel it. Not hostility toward Sandra. Not yet. But a particular kind of stillness that comes over people when they are holding documents in their hands that don't match what they're being told. People were looking at the printed copies I'd passed around. Looking at them, and then looking at Sandra, and then looking at them again. A woman in the 3rd row, Evelyn, a retired schoolteacher who'd lived in the community for 14 years, said, not loudly but clearly enough for the whole room to hear, these lot numbers are different. Sandra said she'd be happy to address the technical details after the meeting with anyone who had specific questions. Evelyn said, I'm asking now. Sandra said the matter was currently in active litigation and that detailed discussion of specific documents was not appropriate in this forum. She said it smoothly, like it was a procedural point rather than a deflection. But the room heard the deflection. Sandra moved to close the new business portion of the agenda. That was when Tom Bellew spoke. Tom was 68, retired banker, 3rd row left side, a man who had lived in the community for 9 years and had served 1 term on the board before Sandra had consolidated her control. He hadn't said a word during my presentation or during Sandra's rebuttal. He'd just sat there reading the documents I passed around, with the focused attention of someone who knew exactly what he was looking at. He said, I'm making a formal motion for an independent financial audit of this association, effective immediately. Sandra said the motion was out of order. Tom said, I'm a board member. Motions from the board are never out of order. Sandra said the audit would require a full board discussion in executive session before being brought to the general membership. Tom said, then I'm formally requesting that executive session be scheduled within 7 days. And I'm stating for the record, and I want this in the minutes, that if that request is denied, I will be contacting the state HOA regulatory board directly. Phil was writing in the minutes. I watched him write it. His hand was steady, but his jaw was tight. Sandra called for a 10-minute recess. During the recess, I stood near the back of the room. 4 people came up to me individually. Homeowners who had been among the most publicly supportive of the pavilion project 2 weeks earlier, when Sandra's TV segment was the only version of events they'd heard. They didn't say much. One man shook my hand without speaking. A woman told me she was sorry this had happened. Another said she'd had her own fine, she'd never understood the basis for. Ray stood beside me the whole time with his arms crossed, not saying anything, just being there. When Sandra reconvened the meeting, she moved through the remaining agenda items in about 4 minutes, and adjourned without taking further questions. She was the first person out the door. Phil was the last. He stopped near the exit, looked around the emptying room, and then looked at me. He didn't say anything for a moment. Then he said, quietly, "I have emails. I didn't know it went this far. I want you to know that." I told him to call Diane's office in the morning. He nodded once and left. I stood in that emptying clubhouse with Ray and looked at the whiteboard at the front of the room. Sandra's agenda, neatly written in her handwriting, every item checked off in order. Ray said, "She's losing the room." I said I knew. He said, "How long before court?" I said 6 weeks. He nodded slowly, the way a man does when 6 weeks sounds about right. The hearing was scheduled for a Thursday morning in November. I drove to the courthouse alone. Diane had offered to have her paralegal pick me up, but I said no. I needed that drive. 40 minutes of empty road and cold morning light and the particular silence of a man who has been building towards something for 4 months and is finally, today, going to find out if it was enough. I wore the same shirt I wear to every project closeout meeting. Dark blue. My father bought it for me years ago and told me it was the kind of shirt that made people take you seriously without trying too hard. I don't know if that's true. I wore it anyway. The courtroom was smaller than I expected. Wood paneling, fluorescent lights, the particular smell of old carpet and recycled air that every municipal building seems to share. The gallery had maybe 30 seats. Ray was in the 4th row. Tom Bella was beside him. Evelyn was 2 seats down. Phil sat in the back corner by himself, hands folded on his knees, looking like a man counting down to something he both dreaded and needed to get through. Sandra arrived with her attorney, a man named Whitfield, expensive suit, the kind of practice courtroom composure that cost $400 an hour. He filed 3 procedural motions before the hearing even formally opened. Diane had responses prepared for all 3. She'd anticipated every one of them. Judge Carla Osei took the bench at 9 o'clock exactly. She was 60, sharp-eyed, with the particular economy of movement that comes from spending decades in a courtroom watching people perform urgency they don't feel. She read Whitfield's 3 motions in silence. Then she read Diane's responses. Then she looked at Whitfield over her reading glasses and denied all 3 motions in under 10 minutes. She said, "Mr. Whitfield, I've read the background on this matter. I'd like to get to the substance today. Please proceed accordingly." Whitfield proceeded accordingly. Diane presented our case first. She started with the lot number. She put the plat map on the projector, the original 1987 document from the county recorder's archive, and she put the HOA's filed version beside it. Side by side on the same screen. She didn't editorialize. She just let the room look at them. The lot number in the original document, Lot 14. The lot number in Sandra's filed version, Lot 41. Then Diane called her document examiner, a forensic specialist named Dr. Patricia Howe, who had spent 22 years analyzing property documents for courts across the state. Dr. Howe explained, in precise and unhurried language, 2 things she had identified in the HOA's filed version. First, the font weight on the altered lot number was measurably different from the surrounding text, a difference consistent with the number having been retyped rather than being part of the original document. Second, the digital metadata embedded in the HOA's electronic filing showed a modification timestamp that post-dated the document's purported creation date by 14 months. Someone had opened that document 14 months after it was supposedly finalized and changed a number. Judge Osei made a note, a long one. Then Diane called Ray Kowalski. Ray walked to the stand like a man who had been in enough difficult situations in his life to know that a courtroom was just another room. He was wearing his good jacket. He'd told me beforehand that he only owned 1 good jacket and he'd ironed it himself that morning. He described what he had observed during the construction, the start date, the workers, the site permit with its timestamp. He produced his photographs. He answered every question Diane asked him in complete sentences, clearly and without elaboration. When Whitfield cross-examined him and suggested he was a disgruntled neighbor acting out of personal grievance, Ray looked at him with the patience of a man who has been insulted by more competent people than this and said, "I've got no grievance. I've got photographs with timestamps. You want to argue with my phone's calendar?" There was a sound in the gallery that was not quite laughter but was close to it. Judge Osei did not smile, but she wrote something down. Then Diane called Phil. Phil had cooperated fully since the morning after the community meeting. He'd come into Diane's office with a USB drive containing 14 months of internal HOA emails and sat across the table from Diane's paralegal for 3 hours going through all of them. He'd been thorough. He'd been honest. And he'd been clearly, visibly relieved to be finally on the right side of something. On the stand, he was nervous. His hands weren't quite still, but his voice was steady. He described his role as Sandra's assistant, the nature of his duties and the specific instruction he had received regarding the easement document. He described Sandra calling him into her office, pulling up the document on her screen, pointing to the lot number, and telling him to, and here Diane read from the email record Phil had provided, "Make sure the lot number matches what we need. Nobody checks these." Phil confirmed that the email was accurate, that he had received it, that he had understood it to mean he should alter the document, that he had done so, that he had not known at the time the full extent of what was being planned, that he wished he had refused. The courtroom was very quiet when he finished. Whitfield cross-examined him hard. He used words like coerced and manufactured and self-serving cooperation. Phil sat through it without flinching and said the same thing at the end of every line of questioning, that the emails existed, that he had provided them voluntarily, and that he was telling the truth. Then it was my turn. I had testified in professional settings before, project reviews, municipal hearings, contractor disputes. I knew how to speak to a room without speaking at it. I kept my hand still on the table in front of me, and I walked the court through the timeline the same way I would walk a client through an engineering project, start to finish, every date, every document, every discrepancy. I used the projected plat map to show the lot number difference. I showed the certified mail receipts with the wrong zip code. I showed the construction permit with its pre-meeting start date. I showed my father's deed restriction, the one-paragraph clause, stamped 1991, that specifically excluded Lot 41 from any future blanket HOA easement claim. I spoke for 40 minutes. When I was done, Judge Osei looked at me for a moment and said, "Mr. Branson, you mentioned your professional background earlier. Civil engineering?" I said yes. She said, "And in your professional experience, is the kind of document discrepancy we've been looking at today consistent with a clerical error?" I said, "No, Your Honor. A clerical error is a wrong date or a misspelled name. A transposed lot number in an easement provision, combined with a metadata modification timestamp 14 months after the document's creation date, is not consistent with clerical error. In my professional opinion, it is consistent with intentional alteration." She wrote that down too. Whitfield put Sandra on the stand after the lunch break. She was, as I expected, exceptional at it. Composed, articulate, unhurried, she maintained eye contact with Judge Osei throughout. She described the lot number discrepancy as an administrative error that had been reviewed by the board's legal counsel and found not to affect the easement's validity. She described Phil's testimony as the confused recollection of an employee who had misunderstood routine document preparation instructions. She described the reclassification as a personal initiative undertaken in her private capacity, entirely separate from her HOA responsibilities. She described Voss Property Solutions LLC as a legitimately selected vendor chosen through a competitive process. She was good. I won't pretend otherwise. If I hadn't spent 4 months inside those documents, if I were a juror hearing this for the first time, I might have found her credible. But Diane had been waiting for one moment. She stood up for cross-examination, walked to the center of the room, and asked Sandra one question. She asked Sandra when she had first become aware of the deed restriction attached to Lot 41's original 1991 purchase, the restriction that specifically excluded the property from any future blanket HOA easement claim. Sandra paused. It was the first pause of her entire testimony. Not long, maybe 2 seconds. But in a courtroom, 2 seconds is a canyon. She said she had not been aware of a deed restriction. Diane entered the document into evidence. The 1991 deed restriction, certified copy from the county recorder's office, stamped and dated, 2 pages behind my father's original deed, exactly where it had always been. Diane noted for the record that the restriction was part of the standard title package that any attorney conducting due diligence on the easement claim would have been required to review, which meant either Sandra's attorney had missed it, which was malpractice, or Sandra had known about it and filed the easement claim anyway. Judge Osei looked at the document for a long time. Then she looked at Sandra. Sandra's expression did not change, but something behind it did. I was watching closely enough to see it, a very slight recalibration, like a machine adjusting to a new set of conditions. She had been caught. She knew she had been caught. And she was already, even sitting there on the stand, thinking about what came next. Judge Osei called a 20-minute recess at 3:15. She came back with a 14-page written ruling. She read the operative findings aloud. The HOA's easement claim was invalid on 3 independent grounds. First, the lot number alteration, supported by forensic document analysis and metadata evidence. Second, the pre-existing deed restriction on Lot 41, which specifically excluded the property from blanket easement claims and which would have been discoverable through standard title due diligence. Third, the procedurally defective board vote, which failed to meet the 2/3 majority requirement established in the HOA's own bylaws. The construction on my property constituted trespass. The HOA was ordered to fund complete removal of all structures on my property, full restoration of the land to its prior condition, and full payment of my legal fees. The HOA's cross-complaint, the one Sandra had filed alleging interference with community governance, was dismissed with prejudice. And then Judge Osei said something that wasn't part of the operative ruling but that she clearly intended to say. She noted that the documentary evidence presented in the case, specifically the forensic findings regarding document alteration and the internal email record regarding the lot number instruction, warranted examination under the state's property fraud statutes. She stated that she would be making a formal referral to the district attorney's office, and that she expected the DA to review the record within 30 days. She closed the ruling. She stood. The bailiff called the room to order. And it was over. I sat at the plaintiff's table for a moment after the room began to empty. Diane put her hand on the table between us, not touching my arm, not making it a moment, just placing her hand there, in a way that said we did it without saying anything at all. I appreciated that. I'm not good with the other kind. I found Ray in the hallway outside the courtroom. He was standing by the elevator with his good jacket still buttoned and his hands in his pockets. I walked up to him and we stood there together for a moment without speaking. Then Ray said, "Your dad would have fought this same way." I didn't trust my voice right away, so I just nodded. That was enough. Phil passed us in the hallway on his way out. He didn't stop, but he looked at me briefly and gave one small nod, the nod of a man who has done the right thing too late but has still, in the end, done it. I nodded back. Then I took the elevator down, walked out into the November cold, and sat in my truck for a few minutes before starting the engine. I thought about Sandra, still upstairs somewhere, talking to Whitfield, already planning the next move, because that was who she was and who she would continue to be. I felt no satisfaction thinking about her. What I felt was something simpler and more complete than satisfaction. I felt like I could go home. So I did. The demolition order was issued 3 weeks after the ruling. I was there the morning the crew arrived. Not Sandra's crew. Not Voss Property Solutions LLC. Not anyone connected to that whole apparatus. A court-appointed contractor, bonded and supervised, with a copy of the judge's order clipped to the foreman's clipboard. I stood at the edge of my driveway with a coffee and watched them work. I didn't feel the need to supervise. I didn't feel the need to say anything to anyone. I just wanted to be present for it. It took 2 full days. The pavilion came down first. The string lights, the HOA signage, the roof panels, the posts, all of it methodically disassembled and loaded into a dumpster. Then the concrete pad, broken up with a jackhammer and hauled out in pieces. Then the gravel path, raked out and removed. Then the parking lot asphalt, lifted in sections, stacked, taken away on a flatbed. By the end of the second day, what remained was bare earth, dark and turned and smelling like soil that had been compressed under concrete for months and was finally breathing again. I walked the perimeter that evening after the crew left. The property line was just a property line again. No signage. No structure. No gravel path cutting across it like it didn't exist. Just the boundary my father established in 1991 and paid good money to protect, exactly where it had always been. The oak tree was fine. The bench was fine. The lake was still. I sat on that bench for a long time. I had called a native plant nursery the week after the ruling. It took me 3 calls to find the right one. A small family-run operation about 40 minutes from the property, hand-lettered signs, more plants than square footage. When I explained what I needed, a wildflower seed mix native to the region, attempting to match a planting done in 1993. The woman who answered went quiet for a moment. She said, "Who planted it originally?" I told her my father's name. Another pause. Then, "I knew him. He came in here a few times back then. I think I still have his purchase records." I had not expected that. I had expected a transactional call. Describe what I needed, get a recommendation, place an order. I had not expected to be sitting in a parking lot on the phone with a woman who remembered my father buying wildflower seeds 30 years ago and had the receipt to prove it. She matched the mix almost exactly. 12 native species. Ready in a week. I picked it up myself. The landscaping team came the day after demolition finished. They graded the bare earth, corrected the compaction from the concrete pad, laid the seed mix in careful rows with small orange flags marking each section. The foreman told me not to expect visible growth until spring. The seeds needed winter cold to stratify properly. By April, I'd see shoots. By June, it would be coming in thick. I stood at the edge of that seeded earth in the late afternoon light and thought about the fact that the most alive thing on this property right now was invisible. Underground. Waiting. That felt right somehow. Sandra resigned from the HOA presidency 6 weeks after the civil ruling. The resignation letter was 4 paragraphs long and contained no admission of wrongdoing. It described her departure as a personal decision. It thanked the board. It wished the community well. It was, in its way, a masterpiece of saying nothing. The DA's office had opened a formal criminal investigation into the document alteration 2 days before her resignation. The timing was not a coincidence. Whitfield had advised her that remaining in a public position during an active criminal inquiry was not in her interest. She had taken that advice. The county planning board rejected the reclassification application the same week. The boat tour company moved to a different lake community 40 miles away. Sandra's consulting firm went dormant. Voss Property Solutions LLC was dissolved 3 months after the ruling. Phil was not charged. His cooperation had been thorough, documented, and voluntary. The DA's office noted his assistance in their preliminary findings. As of the time I'm telling you this story, the criminal investigation into Sandra Voss remains open. The documents are solid. The emails are solid. I'll leave it at that. Tom Ballou was elected interim HOA president 5 weeks after Sandra's resignation. The vote wasn't close. His first order of business was the independent financial audit he had demanded at the October meeting. The findings came back in 6 weeks and were distributed to all 34 homeowners. It was an uncomfortable read. $23,000 in expenditures over Sandra's 3-year tenure could not be fully accounted for. The audit also identified 4 other vendor contracts with structural similarities to the Voss Property Solutions arrangement. Personal connections, no documented competitive bidding, budget line items created and approved through the same procedurally defective process. Everything was referred to the DA's office as supplementary material. Tom restructured the board, added 2 new members to proper process, dissolved the Architectural Review Committee pending charter review, and reconstituted it 3 months later with a conflict of interest policy that prevented any board member from holding multiple committee chairs simultaneously. He also reviewed every fine issued under Sandra's presidency. 14 were found to lack documented basis under the HOA's own bylaws. All 14 voided. All amounts refunded. Ray got a check for $600. He called me when it arrived and said, "I'm buying a new fishing rod." I told him he'd earned it. Tom called me personally 2 weeks after the audit findings were distributed. Sunday morning, which told me he'd thought about the timing. Not a business call. He said, "I owe you an apology on behalf of this association. What happened to your property should never have gotten this far. The board failed in its oversight responsibility, and I was part of that board. I'm sorry." No excuses. No explanation of the social dynamics of opposing Sandra, just the apology, plain and direct. I told him I held no ill will toward the community, toward the neighbors who had signed Sandra's flyer or supported the pavilion because they'd only ever heard one version of events. I understood how that happened. I'd watched it happen in real time. I said, "What I'm asking going forward is simple. Read your documents, attend your meetings, ask questions when votes happen faster than they should. That's all." Tom said he would make sure of it. I believed him. Ray came over on a Saturday morning about a month after the restoration finished. I made coffee. We sat on the cabin porch facing the lake. The seeded earth was still bare, December by then, cold and gray, the orange marker flags standing in their rows. Ray looked at it the way an experienced man looks at something that is going to be fine. He drank his coffee and said, "Already looks better than that parking lot did." I laughed. Genuinely, for what felt like the first time in months. We sat in comfortable silence after that. Ray eventually said, "Glad you had the paperwork." I said I was glad he had the photographs. He nodded, finished his coffee, stood up and shook my hand. Not a greeting, not a formality, something more like a punctuation mark at the end of a long and difficult sentence. Then he walked back toward his lot, hands in his pockets, unhurried, the way a man walks when he's exactly where he belongs. I called my sister that evening. I told her the restoration was done. The seeds were in. The bench was stained, and the oak tree was fine, and the lake was the same as it had always been. She was quiet for a moment. Then she cried, but differently than before. Not frightened. The other kind. When she stopped, she asked if she could come visit in the spring when the wildflowers came in. I said yes. I said I'd leave the porch light on. After I hung up, I sat on the porch in the dark looking out at the lake. The orange marker flags were invisible, but I knew exactly where every one of them was. I could have walked to any of them without a flashlight. I thought about my father, the way he used to sit in this exact spot every morning before anyone else was up, just watching the lake. I used to think that was something you did when you ran out of other things to fill the time. I understand it better now. It wasn't about having nothing to do. It was about knowing in the most concrete and physical way possible that this was yours, that the boundary lines were where they were supposed to be, that the land would be here tomorrow the same as it was today. That's what he was doing every morning. He was just checking in. I do it now too. It's April now. I'm sitting on my father's bench facing the lake, and the wildflowers are coming in. Not fully, just thin green shoots pushing up through the bare earth, delicate and certain at the same time. The nursery owner said by June it would be thick. I believe her. My sister arrives next weekend. I've already stained the porch railing, already stocked the kitchen. I want her to care about this place the way I do. I wanted to still be here for her grandchildren someday. Boundary lines exactly where they are supposed to be. Documents saying exactly what they are supposed to say. I've been thinking about what I actually want to say to you. You have the story. Every document, every courtroom moment, every night I lay in the dark watching that floodlight cycle on and off outside my window. You have all of it. What I want to talk about is the part that almost didn't happen. Sandra understood something about most people, and she wasn't wrong. Most people, when faced with a polished woman and a manila folder and a $400 an hour attorney, will calculate the cost of fighting and decide it's too high. Because the fines pile up. The rental income disappears. The TV segment runs. And somewhere around day 48 you're lying in the dark thinking, maybe it's not worth it. I had that moment. I meant it when I told you that. What got me through it was 3 ordinary things. Documentation. My father read everything twice and kept physical copies and had a deed restriction written in at closing because he believed in doing things properly. That one paragraph, stamped 1991, sitting 2 pages behind his deed in a county archive, ended Sandra's case. Read your deed. Know your lot number. Know your restrictions. These are not formalities. They are the infrastructure of your ownership. Community. Ray Kowalski had no legal obligation to photograph that site permit, collect 9 signatures, or show up to a courthouse in his one good jacket. He did all of it because he was paying attention. Know your neighbors. Know who pays attention. Because when something like this happens, and in HOA communities it happens more than you'd think, the people around you are either your greatest resource or your greatest vulnerability. Steadiness. Sandra was counting on the weight of the process making me feel like I was on the wrong side. Don't let it. The facts were always there. The truth was always in the recorder's archive, waiting for someone to go and find it. Stay steady long enough to bring it forward. My father used to say the land doesn't lie. I think he was right about property law too. The records are there. The truth is always in the documents somewhere. You just have to be the person who goes and finds it. If this story felt familiar, drop it in the comments. These stories deserve to be told. Subscribe for more. New video every week. I'll see you next time.